I am now going to read into the record for the jury and for the public the first attachment for this case, and this is the attachment notice to Jennifer Nolan on 2009-09-09. So that's the 9th of September 2009, 2 months before the court meeting in Sydney. You can see from the free man, commonly called Peter Andrew Nolan, I've crossed out the address of the party of the mailing that I was using. 2. Lawful notice to respondent Miss Jennifer Marguerite Nolan, 12 Brixton Lodge, Foxrock, County Dublin, Ireland. Lawful notice to respondent Mrs. Jennifer Marguerite Nolan, 12 Brixton Lodge, Foxrock, County Dublin, Ireland. Let right be done, though the heavens may fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal, in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state that the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as a respondent. This particular affidavit was with respect to the unlawful seizure of personal property. Jennifer refused to give back my personal property for some 2 years, and she did eventually give back this property. Okay, so this is, but I am reading this into the record because I want the jury to hear that this woman was so vicious and petty that she even tried to say she should get custody of my cats and my hats and my CDs. Not just the children, but hats and CDs as well. This is how petty and selfish and vindictive and nasty this woman chose to be, right? After knowing me for 32 years, she refused to hand me back my personal CDs. So 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that respondent has retained possession of personal possessions of principal since November 12, 2007. Principal makes oath that these possessions include music CDs, computer books supportive of principal professional pursuits, collection of caps which is of sentimental value to principal. Principal makes oath that he has asked politely for the return of these goods in writing both via family, respondent's father, and via respondent's solicitor in Ireland. Principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to retain possession of the personal possessions of principal and believes sincerely that none exists. Okay? And then I have signed it and dated it with the juror, etc. Now I have blanked out the signatures. Should a member of the jury wish to confidentially have a copy of the original document with the original signatures on it, that can be provided. But into the public, I want to protect the identity of those people who witnessed my statements. The notice of intent and proposed remedy that I served on her was, based on the fact that respondent continues to retain the personal possessions of principal, the principal proposes the following intent and proposed remedy. On the basis that principal insists that respondent prove, on this basis, principal insists that respondent prove proof of claim as follows. 1. Respondent to provide proof of claim that she has lawful right to retain personal possessions of principal. Should the respondent be unable or unwilling to produce proof of claim for lawful right to retain the personal possessions of principal, the following remedy is proposed. Respondent to make remedy payment to the amount of €5,000 to the AIB Bank account number, and that's my account number there, in the name of Peter Nolan. Should the respondent be unable or unwilling to make the proposed remedy within 10 days of this date, this notice the principal retains the right to obtain a default judgment from a notary public or to form a court de jure and present matters of fact to the court de jure. The principal retains the right to have the court de jure make decision as to whether the respondent has lawful right to retain the personal possessions of principal and as to the amount of money to be paid as remedy. And I signed that. Now, as I said, she did actually finally give me back my own property, but that a man has to go to that extent after 2 years to get his collection of hats back, which he's collected from all over the world during his travels, or to get his collection of personal CDs back, which he's collected over a lifetime. This is the level of vindictiveness that the respondent entered into. Okay? Now the next one, again from the man commonly called Peter Andrew Nolan to the respondent. This affidavit was with respect to a loan given to me by my brother Christopher Nolan. In the 80s, my brother was making good money and he offered me a loan to help pay down the mortgage on our house. I agreed to it as a loan and agreed to pay it back. Okay, because I didn't want charity from my brother. I wanted to buy my house by myself, or my wife and myself, and certainly my brother had no obligation to give me any money. The agreement was between my brother and myself, and Jennifer had no part in the agreement. During the divorce, she claimed that it was a gift. That is rubbish, and I deny it, and she was not even involved in the conversation. My brother, given that Jennifer said it was a gift and she'd made up a lot of fuss and a lot of problems, my brother suggested that he should just call it a gift, and I said no, he's owed that money, and if I will give that money back to him, I will get it from Jennifer and give it back to him. If he then wants to give that money as a gift to his niece and his nephew, then he may do so. Okay? Or if he wants to give that money to anybody else, he may do so. But that's his choice to give his money to somebody else. It is not Jennifer's prerogative to decide that an agreement between my brother and I was a gift and not a loan. Okay? So this woman is so selfish and so greedy, she will even lie under oath so as to claim that an arrangement made between two people that she was not even present at is somehow a gift so that she gets that money. This is how greedy and selfish this woman is, and that is what this affidavit is about. So, I commonly address by the calling of Peter Andrew Nolan, hereinafter the principal, in my correct public capacity as beneficiary of original jurisdiction, being of majority in age, competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, do state the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as respondent. Affidavit with respect to repayment of loan by Christopher Nolan. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that in or about the year 1989 he was extended a personal loan from his brother Christopher John Nolan for the amount of approximately 25,000 Australian dollars. Principal makes oath that this loan was put towards the reduction of the mortgage in the family home and was intended as a temporary benefit to assist Principal provide for his family. Principal makes oath that he has asked politely for cooperation from respondent to clear this loan and to repay Christopher John Nolan, the principal, an appropriate interest of $25,000, making a total $50,000 to be repaid from the proceeds of the sale of the family home. Principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to retain possession of the personal loan made by Christopher John Nolan to Principal and believes sincerely that none exists. And again, I have signed it. You're welcome to go through and read these to be sure that it looks legitimate to you. This was on the 23rd of the 9th, 09. Again, the signatures are there. The notice of intent and proposed remedy. Based on the fact that respondent continues to refuse to apply her signature to repay the loan made by Principal by Christopher John Nolan, the Principal proposes the following intent and proposed remedy. On this basis, Principal insists that respondent provide proof of claim as follows. 1. Respondent to provide proof of claim that she has lawful right to retain possession of the personal loan and appropriate interest of the amount $50,000 Australian dollars. Should the respondent be unable or unwilling to produce proof of claim for lawful right to retain possession of the personal loan and appropriate interest of the amount $50,000, the following remedy is proposed. Respondent to apply her signature along with the signature of Principal to make remedy payment of the amount $50,000 in favour of Christopher John Nolan. Should the respondent be unable or unwilling to make the proposed remedy within 10 days of this date of this notice, the principal retains the right to obtain a default judgment from a notary public or to form a court de jure and present matters of fact to the court de jure. The principal retains the right to have the court de jure make decision as to whether the respondent has lawful right to retain possession of the personal loan and appropriate interest of the amount $50,000 and as to the amount of money to be paid as remedy. Yours sincerely, signed by myself. Okay, 23rd of the 9th, 09. Next one. This is an affidavit with respect to payment of fees to Philip Lee's solicitors in Ireland. To explain this to the jury, the situation was that Jennifer went into the AIB bank at our local branch in Dun Laoghaire in Dublin. She stole 18,000 euros out of the company bank account. This was the crime of embezzlement. She was the director of the company and did have signing rights to the company account, but as all you jury members will know, just because you've got signing rights to a company bank account does not mean you can waltz in and take money out of the company bank account. As a director, you have legal obligations and fiduciary responsibilities to the corporation. One of them is you can only apply your signature when it's in the interest of the corporation, and that has to be agreed by the relevant parties in the corporation. So Jennifer stole 18,000 euros. So in order to get the 18,000 euros back, I had to engage a company solicitor, and these were Philip Lee solicitors in Dublin. Now, Philip Lee solicitors charged me 9,000 euros to get the 18,000 euros back. Okay, so I was at least 9,000 euros up. However, when Jennifer went to the family law courts, she insisted on having her solicitor serve documents on Philip Lee solicitors. And Philip Lee solicitors were not family law solicitors and kept sending documents back. So Jennifer and her solicitor started sending lots of stuff to Philip Lee solicitors, and they kept sending them back. And the final bill for Philip Lee solicitors was approximately 23,000 euros. So Jennifer is responsible for repaying the 23,000 euros for Philip Lee solicitors based on the fact that she was the one who caused them to be engaged by stealing 18,000 euros out of the company account. Okay? So that's what this affidavit is about. So starting at the top, and this is now read, this was signed under oath, and it is being read into evidence under oath. I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal, in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, to state that truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as respondent. Affidavit with respect to payment of fees to Philip Lee. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. Principal makes oath that due to actions taken by a respondent in the illegal theft of money, 18,000 euros, from the company known as Instant Business Intelligence, Principal was required to retain counsel, Philip Lee solicitors, for the company Instant Business Intelligence. Counsel was required to enter into discussion and draw draft letters with respect to regaining the 18,000 euros illegally stolen by respondent. 4. Principal makes oath that respondent issued further instructions to her family law solicitor to attack and damage the Instant Business Intelligence company. Principal was required to retain counsel to defend the Instant Business Intelligence company, and this caused further fees to be consumed by Philip Lee. 5. Principal makes oath that he has asked politely for cooperation from respondent to clear this debt and repay Philip Lee the amount of approximately 22,885 euros by applying her signature to a combined transfer of funds to Philip Lee from the proceeds of the family home. 6. Principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to refuse payment of the properly incurred expense for the Instant Business Intelligence Company and believes sincerely that none exists. Okay, you can see that I've signed it, 23rd day of the 9th month of September in London, England. You can see that it was witnessed, and you can see the original signatures if you wish. This was my notice of intent and proposed remedy. This debt was never extinguished. Jennifer is still responsible for this debt from the proceeds of the house. So when I take the entire proceeds of the house off her, I will repay this debt. Based on the fact that respondent continues to refuse to apply her signature to pay the lawfully and legally incurred debt on behalf of the Instant Business Intelligence Company caused by respondent's direct actions, principal proposes the following intent and proposed remedy. On this basis, principal insists that respondent provide proof of claim as follows. 1. Respondent to provide proof of claim that she has lawful right to refuse the payment of this properly incurred debt of €22,885. Should the respondent be unable or unwilling to produce proof of claim for lawful right to refuse the payment of this properly incurred debt of €22,885, the following remedy is proposed. 1. Respondent to apply her signature along with the signature of principal to make payment of this properly incurred debt for $22,885 in favour of Philip Lee Solicitors. Should the respondent be unable or unwilling to make the proposed remedy within 10 days of date of this notice, the principal retains the right to obtain a default judgment from a notary public or to form a court de jure and present matters of fact to the court de jure. Principal retains a right to have the court de jure make decision as to whether respondent has lawful right to refuse the payment of this properly incurred debt of €22,885 and as to the amount of money to be paid as remedy. And I've signed it. Okay, now the next is a notice of communication. It went to Jennifer Marguerite Nolan at her address. It also went to Judge Griffin at the law courts and to Registrar Johnson and Louise Henderson. So this is being read now into the record under oath and penalty of perjury and full commercial liability. To whomsoever this may concern, I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal, in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, make the following notice to those who may wish to communicate with me. So this is a notice of methods of communication. Principal hereby notices the recipient of this notice of agreeable method of communication for the purposes of timely and peaceful performance of business, trade, and dispute reconciliation. All documents to be delivered to principal must be affidavits signed under oath and penalty of perjury and full commercial liability. Should you wish to communicate something that does not require attestation or oath, then you may do so. However, it may be discarded without dishonour and without response. In order to perform business in a timely manner, principal will accept documents directed to a private fax number. The principal will then accept the formal hard copy documents delivered by a registered mail inside the following 10 days. Principal hereby notices forward copies of documents will be accepted to the fax number, and there is a private electronic fax number presented, okay, which is now no longer valid. Should the reader wish to send documents to the legal fiction strawman known as Peter Andrew Nolan, please use the following addressing and send follow on mail as registered mail to. And I put my address in there. So I said you can send me a forward copy to this fax number and send me the real copy to this address. Should the reader wish to send documents to the human being spirit of a man commonly called Peter Andrew Nolan, please use the following addressing and send follow on mail as registered mail to, and I gave the address again, and I signed it. So what I'm reading into the record for your benefit is to explain to you that I sent these default judgments to Jennifer's home address and to Louise Henderson, and I said you can, if you wish to reply to this fax number and send the signed copies or certified copies to this address, and that is how you can communicate with me. Okay, so I want to make it clear that I proposed a very simple and straightforward method of these people responding to me. This hereby completes the reading into evidence of the notice to Jennifer Nolan 2009-0909, which was actually dated, the documents were actually dated the 23rd of the 9th, 09. Thank you very much for listening. I shall now read into the record the notarized default judgments following on from the prior video presentation. This first one is actually for Louise Henderson and not for the respondent, Jennifer Marguerite Toal. However, I am reading it into the record at this point in time because I want you, the audience, in the Jennifer Marguerite Toal case, the audience and the jury, the public and the jury, to see that a default judgment was issued against Louise Henderson for the theft of my house. In the case with Louise Henderson, that information will be, of course, included. So I shall read this. I went and got the default notices notarized by a public notary, Stuart Lawrence Niven of 91 George Street, Parramatta. He's a public notary, authorised and sworn, practising in the city of Parramatta in New South Wales. This notice was served on Louise Henderson. Okay? So in the first instance, I will read the entire form and then I will just go through each default judgment. So each of these default judgments has got the same information at the front of it from Stephen Lawrence Niven. Okay, so Form 3, General Certificate as to execution of documents in presence of a notary as witness. So I signed them, he notarized them. Parramatta, New South Wales, Commonwealth of Australia. To all to whom these present shall come. I, Stuart Lawrence Niven of 91 George Street, Parramatta, public notary, duly authorised, admitted and sworn, and practising in the city of Parramatta, in the state of New South Wales, in the Commonwealth of Australia, do hereby certify that I was present on the 24th day of November in the year 2009 and did see Peter Andrew Nolan, the person named in hitherto annexed, duly signed, seal and evidence, the said affidavit, and that the name thereto subscribed is in the proper handwriting of said Peter Andrew Nolan, and that the same Stuart Lawrence Niven thereto subscribed as the witness. Thereto is the proper handwritings of myself, Stuart Lawrence Niven of 91 George Street, Parramatta, New South Wales, Australia, the subscribing witness hereto, in faith and testimony whereof I have hereto subscribed my name and affixed my seal of office at Parramatta aforesaid this 24th day of November in the year 2009. Stuart Lawrence Niven's signature, that's his seal. Okay. Now I made the mistake of giving the originals to Jennifer and keeping the copies, but such mistakes happen. Clearly this is being presented to a jury. Clearly I had this done, and if you want to call Stuart Lawrence Niven to testify or make a statement, you're welcome to do that. So, lawful notice to the respondent, 24th of November 2009. Lawful notice to respondent, the human being calling herself Louise Henderson. So this was addressed to Louise Henderson. And what I'm doing now, I signed it under oath on the 24th of November 2009. I'm now reading it into evidence as evidence against Jennifer Marguerite Toal that this was served on Louise Henderson. And that on the 24th of November 2009, Louise Henderson was issued a default judgment of guilty for stealing my house. Therefore, on the 26th of November 2009, David Dunkley had no right to even be discussing or negotiating my house, which I owned due to this default judgment, okay, which I had claimed back correctly and properly through a claim of right. So I had issued my claim of right in September 2009. I'd served notice on Louise Henderson to prove that she had any right to sell my house and take the proceeds of my labour, which was my property, and put it into a bank account at Watts McRae and keep it from me. Okay, She failed to respond to that affidavit. I am quite happy to say under oath that she failed to respond to that affidavit, and this default notice was issued. From the time I signed this default notice, the Commonwealth of Australia had no lawful or legal right to do anything with my property. With the signing of this document, Louise Henderson was guilty of theft of my property. Okay, the 24th of November 2009. Now it says, I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling herself Louise Henderson, also acting as Federal Magistrate Louise Henderson, hereinafter known as the respondent. Affidavit with respect to the unlawful theft and sale of 8 Schofield Parade Pennant Hills between Jennifer Marguerite Nolan and Peter Andrew Nolan. So, firstly, principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavits and notice of intent and remedy into the British Royal Mail as registered mail addressed to the respondent at the address on the Australian Family Court in George Street, Parramatta on September the 23rd, 2009 and October 23rd, 2009. Principal makes oath that he is not in receipt of this lawful notice by return mail and therefore sincerely believes that the lawful notices were duly presented to the respondent. Principal makes oath that he has also sent many faxes to the listed fax number for the respondent in a further effort to offer the hand of peace in discussing and negotiating an amicable resolution to the issues at hand. The fax number used was 6102 9893 5600. Copies of the transmissions and receipt can be presented as evidence should the respondent wish. Principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to the proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120 and believes sincerely that none exists. Louise Henderson never presented any material facts or evidence to show that she had any right to retain the proceeds of that property. Has never been shown, not by Louise Henderson and later on not by David Dunkling. But remember, this is the date of this affidavit is the 24th of November 2009, 2 days before the court meeting, a default judgment saying that Louise Henderson had never shown this information. You can see that I've signed it. You can see Notary, Commonwealth of Australia. Okay? This was signed and notarized by a notary in the Commonwealth of Australia. So you people sitting on the jury, this is a legally binding document. It is a default notice. It's notarized by a notary in the Commonwealth of Australia. Louise Henderson owed me my house back. Okay? And this stands up in any court in the land, in fact. Now you are a common law court. If you have a question as to the validity of this, you can discuss it with the expert in common law. He will tell you that it's valid. So the notarial notice of non-response and default judgment. To date, respondent has given no response to the September 23rd, 2009 entitled Affidavit with respect to unlawful theft and sale of 8 Schofield Parade, Pennant Hills between Jennifer Marguerite Nolan and Peter Andrew Nolan, and has received no response from a similar affidavit placed in the Royal Mail on October 23rd. Copies of documents provided are included in the envelope with this affidavit, and that's what I did. I gave her copies of those documents. The period for lawful response of both these affidavits has expired. Okay, so I offered Louise Henderson an opportunity to respond and say, show me the evidence you have for retaining the proceeds of my property, and that expired. In all systems of law, silence is consent. Non-response is to admit guilt. Okay, so Louise Henderson is guilty of stealing my house on the 24th of November 2009. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent irrevocable estoppel by acquiescence, barring the bringing of any future claim of defence against this default judgment. So Louise Henderson cannot defend this. The default judgment issued is that given the respondent was not willing to rebut the affidavit or to provide proof of claim that she had lawful right to retain the proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 21220, the respondent is hereby required to immediately, on receipt of this default judgment, issue the appropriate paperwork order to transfer all proceeds of the property known as 8 Schofield Parade, Pennant Hills, New South Wales 2120, an amount of approximately $290,000 held with Watts McRae, to the following bank account. And that was my St George bank account at the time. Failure to immediately, meaning 5 p.m. Wednesday, 25th of November 2009, immediately, the next day. Failure to immediately obey this default judgment will result in a further remedy default judgment of $10 million being levied against the respondent to be paid from the respondent's personal property. Respondent is required to notify principal of the issuance of said paperwork via means described in the notice of communication and documented fax number immediately the paperwork is issued. No fax on that fax number will be interpreted that the respondent has refused to comply with its lawful default judgment. Both this judgment and this further remedy default judgment may result in one or more of the following. 1. A lien against the personal and commercial businesses and property of the respondent. A writ of execution to recover the amount of $290,000 from respondent's personal property. A writ of execution to recover the amount of $10 million from the respondent's personal property. Further, the respondent is hereby charged with the common law crime of theft. The principal shall, at his earliest convenience, impanel a court de jour and present facts of the matter to a court de jour. The court de jour will decide what penalty, if any, to impose on the respondent for the common law crime of theft. You can see I've signed it, and you can see that Stuart Lawrence Niven has notarized it. Okay? So the reason I wanted to read this into the record, and you can see the date, 24th of the 11th, 09. The reason I wanted to read this into the record for the case against Jennifer Marguerite Toal is this document proves that as of the 24th of November 2009, ownership of the proceeds of the $290,000 thereabouts from the property of 8 Schofield Parade, Pennant Hills was my property, even according to the legislation of the Commonwealth of Australia. Okay? My property. Nobody produced any evidence that said otherwise. So they defaulted, and that is my property. Okay? Now, next thing is I'm going to read the other 3 default judgments. You can see this, the first page is the same. This is the default judgment for the repayment of fees, I believe, for Philip Lee. Okay. So, lawful notice to respondent, Miss Jennifer Marguerite Nolan, with her address. I shall read the whole thing in again because this is testimony under oath. So, I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age and competent to testify, a self-realized and free sentient man, my yes be yes, my no be no, to state the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as the respondent. Affidavit with respect to payment of fees to Philip Lee. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the Irish Mail as registered mail addressed to respondent at the current address of the respondent. That is the affidavit that you saw me read into the record just a little while ago. Okay? Principal makes oath that a short time later, said mail was sent to the return to sender address and was seemingly refused for collection. Principal was not aware if respondent had moved house. Principal makes oath that he was subsequently emailed a financial statement from respondent's Australian family law solicitors which continued to have the above address for the respondent. So it looks like the respondent returned the document returned to sender, refused to accept it, and you can't refuse to accept an affidavit, okay? When it's delivered to you in your area, in your place of residence. That is served. If you return it to sender, that's your bad luck. Principal makes oath that he was subsequently emailed a financial statement. Oh, sorry, I just read that. So she was still living at the address, she just sent it back. So principal makes oath that he is in the sincere belief that he made every effort to lawfully and peacefully present the affidavit and notice of intent and remedy by firstly approaching a professional service agent who declined and then sending the notice by registered mail. So I approached a professional service agent in Ireland and offered him €100 to deliver this document, and he said no because of the contents of the document. Okay. So I was required to send it by registered mail because, of course, if I turned up at Jennifer's house, she would call the police and have me arrested and thrown in jail. Okay, so she was sent that. I tried to get a serving agent to serve it. I was refused. I sent it via registered mail. It was turned away. If I went there myself, I would most likely be arrested and incarcerated. So I made every effort to serve that document on Jennifer peacefully. She refused to accept it, and so you, the jury, can decide whether she should have accepted it or not. Okay? The principal makes oath that he was in fear of kidnap and incarceration should he attempt to go to the address listed and serve the document himself. Jennifer has a history of having me kidnapped and incarcerated by making false allegations to police. 8. Principal makes oath that respondent has previously had him unlawfully kidnapped and incarcerated, and respondent has noted in her subsequent affidavits that she contacted the criminal element called the police in Ireland to determine if she could further have principal kidnapped and incarcerated unlawfully. I make that under oath. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to refuse to accept lawful notices when presented in peace by the registered mail and believes sincerely that none exists. Principal has not seen or been presented with any material fact or evidence that show responsible has any lawful right to retain possession of the fees which were legally and lawfully accumulated against the Instant Business Intelligence Company in an effort to defend the company from the actions of respondent and believes sincerely that none exist. So Jennifer has never produced evidence as to why she can do this, and she's required to produce evidence of that. In absence of evidence, I'm making the presumption that she can't do that. You can see that I have signed it. You can see it was the 24th day of November 2009 near Sydney, Australia, and you can see it was notarized by Stephen, what's his name? Notarized by Stuart Lawrence Niven. You can see it was notarized. Okay. Notary Public, Commonwealth of Australia, done deal. So, notarial notice of non-response and default judgment. To date, respondent has given no response to the affidavit with respect to payment of fees to Philip Lee and the attached notice of intent and proposed remedy issued by the principal and claimant addressed by the calling of Peter Andrew Nolan, a free man, within 10 days time period. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any future claim against this default judgment. The default judgment issued is that given to the respondent. The default judgment issued is that given the respondent was not willing to rebut the affidavit or apply her signature to pay the fees as proposed in the remedy, the respondent has hereby forfeited her right to being a signatory to the fees payable, and that the fees have become sole property of the principal to disperse the payment of these fees to Philip Lee. Meaning, I get the money from the house and I pay Philip Lee because she refused to pay Philip Lee. This default judgment has higher status in law than the private run-for-profit company calling itself the Australian Federal Magistrates Court. Okay? And authorised representatives of the private run-for-profit company calling itself the Australian Federal Magistrates Court is hereby instructed to issue orders to transfer the amount of $36,800, meaning 23,000 euros, to the following bank account. Okay? Meaning Louise Henderson, but she didn't do it. From this account, principal makes oath to forward the full amount to Philip Lee's solicitors. Okay, this amount was never transferred. You can see I've dated it again. Stuart Lawrence Niven has witnessed, signed, notarized. This document may be used in a judicial proceeding. That's what this is. This is now being presented to a common law court. That's what it's being presented to. This document is being used in a judicial proceeding. Next, this is a default judgment for the loan given to me by my brother Christopher. Okay, again, notice, and these, I will just say, these notices were handed personally to Jennifer in the court meeting. Okay, as she walked into the courtroom, she was served these notices. And I'm prepared to say under oath, I served these default judgments on her as she walked into the court meeting. So as she walked into the court meeting, she was served the default judgment for Louise Henderson that said, I owned the entire proceeds of the house. Okay? So before the court meeting, before she got into the room, she was served that default notice. And I want to make that very clear. Jennifer was in possession of the default notice that I owned the entire amount and property of the house before walking into the courtroom. Okay? So this is the affidavit with respect to repayment of loan by Christopher Nolan. I commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary to the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state the truths and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to Jennifer Marguerite Nolan, hereinafter known as the respondent. Affidavit with respect to repayment of loan by Christopher Nolan. Item 1. Principal is of legal age and competent to testify. Item 2. Principal has first-hand knowledge of the facts stated herein. Item 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the Irish mail as registered mail addressed to respondent at the current address of the respondent. The affidavit and notice of intent read previously into evidence. Principal makes oath that a short time later said mail was sent to the return to sender address and was seemingly refused for collection. Principal was not aware if respondent had moved house. Principal makes oath that he was subsequently emailed a financial statement from respondent's Australian Family Law solicitors which continued to have the above address for the respondent. Principal makes oath that he is in the sincere belief that he made every effort to lawfully and peacefully present the affidavit and notice of intent and remedy by firstly approaching a professional service agent who declined and then sending the notice by registered mail. Principal makes oath that he was in fear of kidnap and incarceration should he attempt to go to the address listed above and serve the document himself. Principal makes oath that respondent has previously had him unlawfully kidnapped and incarcerated, and respondent has noted in her subsequent affidavits that she contacted the criminal element called police in Ireland to determine if she could further have principal kidnapped and incarcerated unlawfully. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to refuse to accept lawful notices when presented in peace by the registered mail and believes sincerely that none exist. 10. Principal has not seen or been presented with any material fact or evidence that shows respondent has any lawful right to retain possession of the personal loan made by Christopher John Nolan to principal and believes sincerely that none exists. So Jennifer has never presented any evidence that she had any right to retain the loan made to me by my brother Christopher John Nolan. You can see I have signed it. You can see it's the 24th day of the 11th month 2009, the 24th of November 2009, signed by Stuart, sealed by Stuart, a notary public in Australia. So the notarial notice of non-response and default judgment. To date, respondent has given no response to the affidavit with respect to repayment of loan by Christopher Nolan and the attached notice of intent and proposed remedy issued by principal and claimant addressed by the calling of Peter Andrew Nolan, a free man, within the 10-day time period. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any further claim against this default judgment. She has accepted this default judgment, that means. The default judgment issued is that the respondent was not willing to rebut the affidavit or apply her signature to repay the loan as proposed in the remedy. The respondent has hereby forfeited her right of being a signatory to the claimed money, and that the claimed money has become sole property of the principal to disperse the repayment of this loan to his brother. The default judgment has higher status in law than the private run-for-profit company calling itself the Australian Federal Magistrates Court. An authorised representative of the private run-for-profit company calling itself the Australian Federal Magistrate Court is hereby instructed, Louise Henderson, to issue orders to transfer the amount of $50,000 to the following bank account. That's my bank account number. From this account, principal makes oath to forward the full amount to Christopher John Nolan. Christopher John Nolan is reluctant to personally involve himself in these proceedings and wishes his bank account details not be made known to those who might well do him harm. Signed by me, 24th of November, noted by Stuart Lawrence Niven, signed by Stuart Lawrence Niven, sealed by Stuart Lawrence Niven. This document may be used in a judicial proceeding, which is exactly what is happening. Okay, so Jennifer waived the right to have her signature applied to this loan. She's stealing this $50,000. She stole this $50,000. So this one is for, just go down here. This one is actually for a gentleman by the name of, or a person, I believe it's a gentleman, by the name of Registrar Johnson. Okay, so when they stole my house, the person who signed the document to steal my house was one Registrar Johnson, Judicial Registrar Johnson. Okay, so this default notice was also sent to Judicial Registrar Johnson in this building. And I want to read this into the record in Jennifer's case because, again, this was sent on the 24th of November 2009, again notarized by Stuart Niven. So the lawful notice to the respondent, Registrar Johnson, and I'll read the whole thing. This is again to indicate that at the time, on the 24th of November 2009, the Commonwealth of Australia, as represented by the Australian Federal Magistrates Court, did not own my property, had no lawful claim to my property. Okay? So I, commonly addressed by the calling of Peter Andrew Nolan, hereinafter the principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised, free sentient man, my yes be yes, my no be no, do state the truth and facts herein are of first-hand personal knowledge, true, correct, complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling himself, him or herself, I don't know, Judicial Registrar Johnson, also acting in the judicial person known as Judicial Registrar Johnson, hereinafter known as the respondent. Affidavit with respect to order for the sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan. This Judicial Registrar Johnson was the person who signed the order for the sale. Okay? The sale of the house, and had no right to do so. Never at any point had any right to do that. Okay? Because that right was claimed by deception. 1. Principal is of legal age and competent to testify. 2. Principal has first-hand knowledge of the facts stated herein. 3. Principal makes oath that he placed a copy of the attached affidavit and notice of intent and remedy into the British Royal Mail as registered mail addressed to the respondent at the address of the Australian Family Court in George Street, Parramatta. Actually, I sent it to the other building. Principal makes oath that this mail was never received at the return address and sincerely believes in good faith that this mail was presented to the respondent. So sooner or later we have to put Registrar Johnson on trial. The principal has not seen or been presented with any material fact or evidence that show respondent has any lawful right to refuse to pay his bill for the order that was issued and believes sincerely that none exists. So this registrar issued an order, I gave him a bill for that order, and he has not paid the bill. Okay, 6. Principal has not seen or been presented with any material facts or evidence that show respondent has any lawful right to order the sale of his house and believes sincerely that none exists. Okay, so I challenged Registrar Johnson to show me on what basis he or she had any right to sell my house, and they did not present any evidence of that. Okay. Now, Justin Dowd claimed time and time again that they had every right to sell my house, but the speech by Robert McClellan will put an end to that notion. Okay. Again, you can see I signed it. It was the 24th of November. You see Stuart Niven signed it, notarized it as a notary public, and stamped it. So the notarial notice of non-response and default judgment. Okay. To date, the respondent has given no response to the affidavit with respect to order for sale of 8 Schofield Parade, Pennant Hills, between Jennifer Marguerite Nolan and Peter Andrew Nolan, and the attached notice for bill of services ordered. Okay, so I sent him a bill of services ordered, issued by the principal and claimant, addressed by the calling of Peter Andrew Nolan, a free man, within the 20-day period. Printed copies are included for your information, so I packaged this up and gave it to them. This notarial notice is to advise respondent that respondent's failure to respond has resulted in an automatic default judgment and permanent and irrevocable estoppel by acquiescence, barring the bringing of any future claim against this default judgment. That is, you're guilty. You cannot claim against this judgment. This default judgment is issued. The default judgment issued is that given the respondent was not willing to rebut the affidavit or to pay his lawful bill for his lawful order, the respondent is hereby judged to have acquiesced to the bill for $5.5 million, and this bill is now due immediately upon receipt. Immediate payment can be made to the following bank account. Right? So I sent a bill for $5.5 million to Registrar Johnson. Okay. Now, of course, he doesn't have that money. Okay, but this is where it's going to get interesting now, because you, the jury, can ratify this and say he didn't respond. He issued an order. He must find out the amount for his order before he issues it. Pay the $5.5 million. So failure to pay this bill on presentation of this default judgment may result in one or more of the following: a lien against the commercial, business and property of the respondent, a writ of execution to recover the amount of the bill from the respondent, common law criminal charges of theft to be presented to a court de jure, and for the court de jure to be charged with the responsibility of deciding innocence or guilt and subsequent punishment of the respondent for not paying his or her lawful bills. Okay? So that's what's going to happen to Registrar Johnson. But this is to note that having sold my house, I sent him a bill. You see me autograph. It's the 24th day of November, Stuart Lawrence Niven, his signature, stamp. Okay? This document may be used in a judicial proceeding, which is exactly what it's being used for. It is being used to present this affidavit to the jury that is putting Jennifer Marguerite Toal on trial for her part in the theft of my house. Okay? So that ends the reading of the default judgments. Thank you very much for listening.